Is there a set list of canons of interpretation? So let's just assume the court is not going to be able, because maybe it will never be asked the right questions, so it won't have the opportunity to answer all of the questions that are out there, and there are lots of questions. However, it may develop over time a set of principles that would basically tell the EU legal order and those evolving in it and applying EU law, when you look at a regulation, this is how you should read it. When you interpret an article in the regulation, this is how you should interpret it. When you study a derogation or an exemption, this is what you can read into it, this is what you shouldn't read into it. How far has the court gone so far in building a corpus of general interpretative guidance to help those who practice the regulations on a day-to-day basis? You are listening to This Month in EU Sanctions, your go-to podcasts for the latest updates, insights, and in-depth analysis of the EU's evolving sanctions and trade compliance landscape. I am your host, Jan Dunin-Wasowicz. In each episode, this podcast examines some of the latest developments shaping EU sanctions law and policy, combining legal and institutional analysis with a practical perspective on implementation, compliance, and enforcement. Subscribe to the LinkedIn newsletter This Month in EU Sanctions to receive a selection of monthly updates, including on the topics discussed on this podcast. As November 2025 drew to a close, the U.S.-led initiative to negotiate an end to the war in Ukraine dominated international headlines. In this context, a key question arose for policymakers, businesses, and compliance professionals. What does the EU's response to the proposed plan mean for the future of EU sanctions against Russia? While the US proposed a peace framework involving Ukrainian territorial concessions, limitations on its military, and the repurposing of roughly $100 billion in frozen Russian assets, with half of the profits going to the US, the EU has maintained, so far, a united stance. The EU's response is not just an immediate concern to the proposal, it sets a long-term precedent for how sanctions will operate in the EU's strategy towards Russia. European Council President Antonio Costa made this explicit at the informal EU leaders' meeting in Luanda on November 24th. The statement noted, "Issues that concern the EU directly, such as sanctions, enlargement, or immobilized assets, require the full involvement and decision by the EU." The EU continuously increased the sanctions pressure on Russia throughout 2025. 3 of the 4 packages adopted in 2025 so far were decided without the US joining. Most recently, the EU's 19th sanctions package, adopted on October 23rd, targeted, among other things, Russian LNG imports, the shadow fleet, and third-country facilitators. These measures tightened existing restrictions, closed loopholes, thus reflecting the EU's determination to limit Russia's revenue streams. EU sanctions against Russia, in other words, are not easing, they are intensifying. In the lead-up to the 19th sanction package, the Trump administration had, for the first time, adopted more sanctions against Russia. Earlier this autumn, the European Commission proposed a reparations loan mechanism using immobilized Russian assets to support Ukraine financially and fund Ukraine's reconstruction while ensuring that Russia bears the financial cost of its aggression. The plan nearly passed in late October, but Belgium raised last-minute concerns about legal structures and risk sharing, thus delaying the agreement. The US proposal to redirect these funds under its control met strong opposition in Brussels. In her address to the European Parliament on November 26, European Commission President Ursula von der Leyen said, "Europe must keep up the pressure on Russia until there is a just and lasting peace for Ukraine." For the EU, these assets are a strategic resource that require collective oversight, not unilateral decisions. In response to the US proposal, the EU tabled a 24-point counterproposal. It rejected territorial concessions, reaffirmed Ukraine's sovereignty, and the European perspective, calling for joint governance of frozen assets. On November 26, 2025, High Representative Kaja Kallas stressed that the need is not so much to stay the course, but to accelerate with more sanctions, more military support, and more financial aid. Across forums from the G20 to Geneva, EU leaders have repeated one principle. Nothing about Ukraine without Ukraine. Nothing about the EU without the EU. Nothing about NATO without NATO. The EU supports the ongoing efforts, but drew a clear line against any deal that would threaten Ukrainian or European security. The EU is already preparing its 20th sanctions package to continue to increase the pressure. The EU is also developing contingency measures to support Ukraine, regardless of US policy. These developments highlight the volatility of transatlantic alignment. Only weeks later, the United States had, for the first time, under the Trump administration, agreed to impose new sanctions on Russia. This serving as a reminder of how quickly the strategic landscape can change. For legal and compliance professionals, the takeaway is clear. EU sanctions are not only enduring, they are tightening. This approach reflects the EU's commitment to Ukraine's sovereignty, international law, and achieving a just and lasting peace for Ukraine. One thing is clear. The EU is playing the long game. I'm thrilled to welcome our next guest, Celia Challet. Celia is an assistant professor of law at the Université Catholique de Lille, where she's part of the European School of Political Science. Her research focuses on EU institutional law and EU external relations law, with a particular emphasis on sanctions adopted under the Common Foreign and Security Policy and their review by the Court of Justice of the European Union. Celia is also an active member of MINOS, the Multidisciplinary International Network on Sanctions, a group dedicated to studying international sanctions from multiple perspectives. In our conversation, we explore the growing role of the Court of Justice in interpreting EU sanctions through references for preliminary rulings, diving into both the legal theory behind these decisions and the practical challenges they create for practitioners. Celia, thank you so much for joining.
Hello, thank you for hosting me.
You've had a specific interest in the role of EU courts in interpreting EU sanctions. How did you identify this issue as a research topic in the first place?
I think it all started a few years ago when we were really at the beginning of the sanctions against Russia process. It was even before 2022. And we could already see that there were some cases mounting before the Court of Justice with very interesting questions with oil drilling companies in Russia, for example, challenging sectoral restrictions, with some close friends of Putin already before 2022 challenging their asset freezes, their individual sanctions against them before Luxembourg. And so, of course, these sanctions already raised at the time questions of proportionality, fundamental rights, adequacy even. So I thought that it would be interesting to delve into that. And the case law post-2022, so since the start of the invasion of Ukraine, has only confirmed all of this. So it's a very dynamic and evolving topic within the EU case law.
So does EU sanctions litigation arise out of a confrontation between the targets and the sanctions authority? Was that the main way the courts were brought into the picture on framing guidance and interpretation?
Indeed, historically, this was the main judicial avenue. I think among the hundreds of cases that we've had since the entry into force of the Lisbon Treaty, so over the past 20 years, let's say, the hundreds of cases that we've had consist mainly of what we call actions for annulment, so direct actions of sanctions targets, mainly individuals, contesting their asset freeze before the Court of Justice. We've seen also some companies, EU companies or targeted companies, challenging restrictions that affect them. And usually what they ask is either the annulment of the sanctions or sometimes some damages, because they consider that their economic or personal interests have been affected and that therefore they should be compensated for that. But recently, we've also seen the rise, still a bit marginal, but nevertheless noticeable, the rise of another judicial remedy, which is the references for preliminary rulings, so questions from national courts before the Court of Justice, which is also very interesting to study.
Would the claimants attack the validity, the legality of the sanctions, or take issue at more of the interpretation of the text and how these measures were interpreted by the others?
I think it depends on the cases. I would say that perhaps usually the main set of arguments revolves around the validity of the sanctions. So, for example, let's say a Russian oligarch who is listed under the sanctions list will challenge the fact that, let's say, his right to property was affected, or that he was listed under false pretenses, or that the EU does not have enough evidence to support the claim that he should be listed as, for example, supporting Putin. But what we've seen also in recent years is that some listed targets, especially oligarchs, not only challenge the validity of the sanctions, but challenge the interpretation that underpins them. For example, some Russian oligarchs who are challenged as being associated with a listed person will say that, well, there are several interpretations of the notion of association. And of course, they argue that the court should opt for the interpretation that suits them. So there's also increasing discussions on really what asset freezes should cover and what the scope of asset freezes should be with respect to individuals.
And that would be the typical action for annulment or so-called delisting petition. How does the reference for preliminary ruling come into play here? And maybe more generally speaking, for our listeners who are perhaps less familiar with the instrument, what is a reference for preliminary ruling?
So a reference for a preliminary ruling is, under this very technical term, actually a quite easy judicial avenue. It's basically a national court of a member state asking a question to the Court of Justice. Why? Because often when national judges have to settle an issue at a domestic level, well, either the national measures or the EU rule that might possibly be applicable in the case sometimes is not entirely clear to them. And sometimes a national judge also wonders whether the EU rule is valid at all. So what happens is sometimes in order to solve the case, they need to suspend the procedure and ask the Court of Justice to either rule on the validity of an EU rule or interpret it. So in other words, they ask the court for help.
Historically, what were the initial questions that were submitted through a reference for preliminary ruling? Was it at all possible to challenge the validity of the sanctions through that procedure?
Actually, it wasn't. And actually, if you look at the treaties, if you have time, you will see that technically preliminary rulings are not mentioned in the legal avenues that are available for people or national courts. Normally, according to the treaties, there can be only actions asking the courts to assess the validity of EU restrictive measures contained in a common foreign and security policy decision. So preliminary rulings were nowhere in the picture of the treaties. But of course, as the case law developed, the EU Court of Justice progressively recognized that actually it is competent to answer questions on the validity of restrictive measures in a decision on foreign policy. And progressively, the court has expanded the interpretation of its own competence. So my answer would be technically no, but in reality, yes, the court is competent and does use its competence to answer questions from national courts.
Because would it typically be the case that the referring court is framing a question around the decision, or would it be limited to a provision of the regulation?
So what happens is, as the case law is now developed, there is a difference between assessing the validity and just interpreting. So as a general rule, usually national judges will ask questions about a regulation provision. What happens sometimes is that either the provision they ask the interpretation is missing in the regulation and is only in the decision, or sometimes in order to rule on the regulation, you also need to look at the CFSP decision. So then what should the court do? And what the court said is that it's always competent to assess the validity of the CFSP decision. What is less certain for the court is whether it can also interpret the CFSP decision.
Because that would be somewhat controversial perhaps not controversial, but it doesn't seem necessarily intuitive for the judiciary to opine on, say, the justifications for a decision, would it?
Exactly. What the court says is that the decision is ultimately a foreign policy decision by member states, and it's not the job of the court to second guess the intention of the member states. Of course, you may well say that this is a bit of an artificial reasoning because the intention of the member states is also in the regulation. And very often the regulation is a bit of a copy-paste of the CFSP decision. But nevertheless, that is what the court says.
Could you give us an example of one of the more the older, I would say? There's of course a lot more recent cases that I think we'll touch on. Historically, in your research, was there what I suppose we would call seminal cases where, in the reference for preliminary ruling context, where really, the gateway moment happened, or it was a watershed moment in the court's case law in terms of how this tool is used and its impact?
Well, I think if you speak to EU sanctions aficionados, the case would obviously be the Rosneft judgment, which was issued in 2017. It was about a Russian company that contested some, let's say, sectoral restrictions, so export restrictions of some oil drilling technologies. And there were also some financial restrictions on this company's access to the EU market. So basically, it was affected by the sanctions. It's challenged the sanctions directly before the Court of Justice. But because Rosneft wanted to be strategic, they also filed a case before a national court. At the time, it was in the UK. And before the UK judges, they said that the national implementing measures by the UK to implement the sanctions were not compatible with EU law. So then they pushed the national judge to ask a question to the Court of Justice. Again, it was not really a problem whether the court could rule on the regulation. This is always a possibility, but the question was, could the court also rule on the validity of the decision? The UK judge himself was not really sure that this actually could happen, but in the end, the court said that it could. So this really opened the gate to further confirm that you can question the validity of EU sanctions through a question to a national judge.
Were there significant cases prior to the 2014 sanctions that caught your attention in the research?
Well, there is, for example, what we call the Afrasiabi case, which is a very interesting case on the Iran sanctions this time. Why? Because it touches upon the question of circumvention, a topic that is very much in the discussions today. Already at the time, there were questions about, well, what does it mean to be circumventing sanctions? Can you be punished under EU rules for circumventing sanctions? Knowing that at the time, the judgment is from 2011, there wasn't much to built upon. In this case, what happened? We had German companies that exported some products to Iran, which were forbidden under the Iranian sanctions. The problem is that they delivered the resource. I think it was an oven or a high technology product, but the product was not functional yet. It was not working. So when the companies were prosecuted by German authorities, they said, well, the product doesn't work. We're not violating the sanctions. We did not breach the prohibition. And here, upon the question of the national judge, the court said that no, we needed to have a broader approach than that circumventing sanctions mean not only violating sanctions actively, but also accepting the risk that what you do or people you trade with might amount to violating sanctions. So of course, very important for practitioners and the EU itself.
And it is a very important case for compliance professionals that has shaped the standard for many years, and now actually embedded in the EU sanctions regulations against Russia, the holding of this case. Would you say that EU courts, through the reference for preliminary rulings, have expanded the reach or the breadth of EU restrictive measures, or has the court's review of these cases been neutral from this perspective, or is it possible to categorize a little bit that contribution?
Of course, it's always difficult, and in our case, perhaps premature to draw final conclusions on the contribution of the case law. I do think that the court is contributing to expanding the scope of restrictive measures, at least on two aspects. First of all, because what we need to remember is that the questions or the problems raised in preliminary rulings are often not the same as those raised in direct actions. When you file a direct action before the Court of Justice, of course, as a lawyer or as a party, your arguments will be shaped by the judicial remedy. So often you will challenge compliance with fundamental rights. You will say that the council made an error of assessment, that there was a lack of evidence. But the questions will revolve a bit less on practical aspects of how we implement asset freezes, what it means exactly to terminate a contract, what it means exactly to prohibit the export of a product and to do border checks. So that means that if we only have direct actions, a lot of crucial questions for the effective implementation of EU sanctions completely go under the radar of the Court of Justice. But thanks to the preliminary questions that we see now, especially in the context of the Russia sanctions, we have some of those very practical, very concrete, very case-determining questions that arrive in Luxembourg.
Let's take a few examples. What are some of the practical questions that were put to the court, and what was the resolution?
For example, so we've also seen, to start with, that there's cases in which sanctions completely impact other areas of EU or national law. So we've had as remote cases as the case of a Syrian national who was asking his country and the country in the European Union to be allowed to pay money to the Syrian state at the time to be exempt from military service. So, because otherwise he would have to come back to Russia and would be persecuted.
Would be a payment.
And there would be a payment, which was forbidden under the Syria sanctions. So what do you do with that? Another example, which is a bit of an older case, but still interesting, was we had a case of a person who bought a building in Germany, paid for the property, and then after that was listed under the sanctions. He had already paid for the house. Nevertheless, the seller was forbidden to give him the house. Why? Because this was now a resource of the listed targets, and therefore it had to be frozen. So it doesn't matter if the resource has been paid, that is too late. And we've seen another example very recently. This is a pending case before the Court of Justice. Some German companies that used to sell aircraft parts to a Serbian company, and they became suspicious that maybe the Serbian company was sending those aircraft parts to Russia. So what the German company did was to refuse to supply the Serbian company with the aircraft parts. What did the Serbian company reply? Well, we've already paid you for that. So in that case, you should reimburse us. And the German company argues that they shouldn't pay them back because this is against the sanctions. So this is, again, another example of very concrete issues in everyday transactional life.
And actually, if you're here referencing the no claims clause or similar provisions, there isn't only just one, but multiple references for preliminary rulings. So it'll be interesting to see if the court is also consistent or finds some logic in how it resolves these individual questions, although even if they fall under the umbrella of the same topic. I thought that under the 2022 sanctions, we're now really starting to see very diverse questions. I mean, maybe not, I haven't mapped out all of the provisions that have now been also brought to the court's remit through the reference system. But it feels like as time goes by, more and more provisions from an interpretative perspective are being tested. And I'm thinking here about the legal services prohibition, which I thought was quite interesting, beyond the fact that, of course, you had a lot of people paying attention to it and, the lawyers, of course, but that there is also a commission FAQ in the mix. Have you also noticed in your research or found conflicts between the guidance, between how the court might view an issue and how the council, the commission, or other actors in the sanctions ecosystem might view them?
I think we still need to see a bit of more cases to see whether the FAQs issue impacts other provisions of sanctions law, but clearly we've seen clashes about the FAQs with respect exactly to the legal services provisions. In the case you mentioned, the German judges really being very dissatisfied with how the Commission interpreted the ban on legal advisory services. This is not necessarily a widespread attitude among judges. We've seen that depending on the member states, the judges might be much more deferent. For example, in the trust fund preliminary questions, the Italian judges refer to the FAQs without really questioning them, and they're very diplomatic with the court. But the German judges usually point out to the deficiencies. So I think this is also giving a hint as to the gap sometimes between the FAQs and how national judges at national level, people deal with them.
Do you have a sense which courts have been sending the most sanctions-related questions through the reference system?
So that all depends whether you're asking this regarding before 2022 or after 2022. It's interesting to see that we've seen really an explosion in the diversity of judges who ask questions. Before 2022, it was mainly from Germany, France, the UK pre-Brexit, and one question from Lithuania. Since 2022, we have questions from Austria, Belgium, Italy, the Baltic countries, and Netherlands. You see that more and more states and more judges have to grasp with the practical issues of sanctions. So that shows also the scale of how we have to enforce sanctions at national level.
Among we mentioned a little bit the types of areas that may be affected by the sanctions and lead to questions in domestic courts. But if we look now more in terms of the catalog of key terms or key notions that have been construed under EU law by the EU courts through the reference, but what would you find if you were to not do a lexicon, but basically if you were to map out, okay, these are the sanctions, these are important sanctions terms that have been interpreted by the Court of Justice, what would you find?
Interestingly enough, I would say that most of the interpretative questions revolve around concepts tied to asset freezes. You would think that asset freezes are not such a difficult notion, right? We list someone, we have to freeze all the bank accounts, the resources. However, this is what gives the judges the most headaches. Based on what I see, you have a lot of judges asking what is meant by what we call the prohibition to make funds available. That is to say, even if the funds are frozen, there might be derogations, or what constitutes an illegal making funds available to an entity. And here we've had a lot of questions about that. A funny one, I think, is a case about the Yemen government. Yemen won an arbitral award, so money is owed to a Yemen ministry. However, the national court suspects that the ministry is under the financial and personal control of a corrupt individual who is under sanctions. So it's quite likely that if we give the money to the Yemen ministry, it will end up in the pockets of the sanctioned individual. Does that amount to making funds available to that person? So this is typically the kind of question that is asked by national judges.
Well, and of course, there's the big question of control. I think the control question has come and is coming again through different cases and from various areas of the union, which I think is very central to the asset freeze context, but has very practical implications, I think, also for practitioners and compliance professionals, obviously.
Indeed, this is the question of ownership and control in the context of trust. It occupies national judges, especially from Italy, for some reason. What they ask sometimes is that if national law or even a clause in the trust says that the sanctioned person cannot benefit from the trust fund, does it still allow the EU to sanction the trust fund as belonging to the sanctioned person? So again, a very practical application of that. So indeed, another very topical issue.
Have you seen the court being asked to opine on jurisdictional considerations of what does it mean to be import into the union or to transfer or to transit or to, who is the actual subject of the obligations? I mean, of course, we have the standard jurisdictional clauses of the regulations, but there's lots of prohibitions and connectors, so to speak, in the regulations and in the practice that give rise quite often to some very practical and legal questions about, where's the line and where does the world of EU sanctions end? I was wondering if the court has had to has been called upon to intervene in such cases.
Mm-hmm. Actually, it has. Two cases come to mind. Actually, you might have heard perhaps of the Neves 77 case, which is interesting for so many reasons. But one of them was that at stake in the case was the prohibition to provide brokering services for military equipment to Russia. So EU companies cannot provide those services. In Neves 77, the military equipment in question never transited through the EU. It never entered the EU territory. So the national judge said, well, can we really sanction an EU company for providing services if the military equipment never touched the EU territory? And the answer was yes, because as the court said, otherwise it would be too easy to circumvent the prohibition. And another case, which I did not expect to see before the Court of Justice, is about the import of wood from Myanmar. Because under the Myanmar sanctions, we are prohibited as EU operators to import wood from Myanmar. And in Germany, we had the case of a company that imported wood from Myanmar, which was processed in Taiwan. So the question was, did it violate the sanctions against Myanmar? And here, surprisingly, the court said that it did not. The court said that if we apply the EU rules of origin, well, the wood was transferred in Taiwan, therefore it no longer came from Myanmar. So I was a bit surprised to see that, because for me, fighting against circumvention would dictate to choose the opposite solution. Otherwise, it's too easy. You just import wood from Myanmar, have it refined somewhere else, and that's it. So I guess that the court here was trying to merely align with the EU customs code. But still, it's interesting to see that the court sometimes does not always have the same approach to circumvention.
Well, and in the Neves case, I think the broker was in the EU, right? It was in Romania. So I think one of the considerations, if I remember correctly, was essentially to say, well, yes, admittedly, the product never touched the EU, but the person who's moving the product from 2 points outside of the EU was subject to jurisdiction and subject to the prohibition against brokering.
Absolutely.
I think EU sanctions law and compliance is fascinating, but also very tough because, correct me if you disagree, but the legal bases in the treaty for adopting sanctions are extremely broad. The regulations are not very detailed in the definitions. Do you view the reference for preliminary ruling as a viable avenue to expect that guidance, or do you think it should be coming from somewhere else, and if so, from where?
A very complex question. Of course, in the ideal scenario, the guidance would come from the decision makers, that is to say the council, perhaps a bit more the commission, with the court only playing a supplementary role. The thing is that we see that in practice, a lot of the questions arrive on the court's docket and the court has to deal with them. I think there is definitely a role for the court to play, though you can see that it's not always adamant to provide definitions when it doesn't have to. I think what the court is trying to look out for, and we see that increasingly in recent cases, is to maintain the consistency and the uniformity of EU sanctions law. And we see the court now looking more and more about, let's say, the internal consistency of regulation, looking at whether provisions contradict each other and how to build a coherent rationale. So we see the court looking at this. It doesn't mean necessarily that it provides definitions, but at least I think it's a welcome development. Now, I think that the court sometimes, indirect action does not have the incentive to make the interpretative efforts that preliminary questions might make it to do. For example, there was a direct case of Friedman, I think, who was complaining about an EU sanctions, I think the reporting obligation for listed targets. And he argued that, well, the notions of ownership and control are so difficult and so contradictory depending on which member states interprets them, that really there's divergent interpretations everywhere and that this doesn't work. The court replied in the direct action that no, actually those notions are fairly clear and that they don't raise enough uncertainty as to really create a problem of legal certainty. Judging at all the questions raised by national judges, clearly the court either misunderstands the nature of the divergent interpretations or did not want to engage with those. But with the questions arriving to the court now, it might be forced to actually answer those questions. So I do think there is a definitional opportunity for the court in those preliminary questions, which again sometimes touch on different aspects and complementary aspects of EU sanctions.
Is there a set list of canons of interpretation? Let's just assume the court is not going to be able, because maybe it will never be asked the right questions, so it won't have the opportunity to answer all of the questions that are out there, and there are lots of questions. However, it may develop over time a set of principles that would basically tell the EU legal order and those evolving in it and applying EU law, when you look at a regulation, this is how you should read it. When you interpret an article in the regulation, this is how you should interpret it. When you study a derogation or an exemption, this is what you can read into it. This is what you shouldn't read into it. How far has the court gone so far in building a corpus of general interpretative guidance to help those who practice the regulations that have direct effect, obviously, on a day-to-day basis?
It's a bit hard to tell right now, but I would say that overall, let's say the court has interpretation methods and the court has overarching principles that it applies. In terms of methods, what we see the court doing now when it struggles is to look at three things: the text of the provisions, and sometimes comparing different linguistic versions, which creates a whole lot of other problems because often linguistic versions are different. So sometimes that doesn't help. Then the court looks at the context, and usually the court will say that the context of, let's say, the Russia sanctions is escalating war, therefore we need to increase pressure on Russia, therefore that justifies a broad interpretation of the sanctions. And the court usually looks at the objectives, which is essentially a bit the same. Now, what I see is that often, and especially in the preliminary questions, the rulings, the court usually advocates for a broad interpretation to ensure, a maximum application of sanctions and to fight circumvention. So usually, when you ask a question to the court, you can be fairly sure that at some point the court will weigh in the effectiveness of sanctions and its response. Another important parameter of the court's assessment is compliance with fundamental rights. And this is an issue that often comes back, be it in direct actions or preliminary questions, and the court will take that into account. For example, this is why the court has been quite severe sometimes with national authorities who refused to release funds for listed targets to pay their lawyers. The court said that the national authorities, by refusing to give the money, were infringing fundamental rights. So this is something also that the court will look at.
This is very interesting, and it may, I think, have its relevance and when you're thinking about a case. And I think we hear more and more this idea that in guiding the thinking about how to apply or interpret the regulations, there should be a notion of proportionality. And I think for a lot of people, this is a notion that's very difficult. In a slightly different context, I remember the Bank Melli case, but in the blocking sanction context, with the reference for a preliminary ruling coming out of the Hamburg, I think, court, it struck me in the conclusions. I think it was the Advocate General, if I remember correctly, that essentially was walking through the reasoning, and ultimately came out saying, well, if we push the reasoning to its end, the result is not going to be ideal. But what else can I say? I'm not here to second guess the council. If you don't like the outcome, you have to change the regulation. So I think there's an interesting, perhaps not tension, but I think on the one hand, there's this huge expectation for the court to fulfill, obviously, its mission in the EU legal order, and it's the sole interpreter. And at the same time, giving various actors in the EU sanctions system its own space, the council, the member states for the implementation, because that's the member states that have made the commitments to follow the decisions, and then the direct effect of these regulations that need to be implemented by the private sector. So I was wondering where do you see the court, basically, in this setup? How do we resolve this?
It's indeed a very difficult question. If I may just answer a side comment first, hearing you talk about this, that makes me think of what I view as a sort of difference of approach by the court on fundamental rights, depending on whether it's an action at national level or whether it's the EU institutions at stake. We know that in general, if you study fundamental rights case law of the Court of Justice, let's say that the Court of Justice is often more prone to find the violations of fundamental rights by member states than by the EU institutions. And this we see with EU sanctions. The court cases where there's been an issue with the national authority refusing to release some funds, even though it had to, we saw the court going full force in the judgment about the right to an effective judicial remedy, the Charter of Fundamental Rights, etc., etc. While in direct actions against council CFSP decisions, very rarely do claims based on fundamental rights win before the Court of Justice. This is really the area of sanctions litigation where the court almost systematically dismisses cases based on fundamental rights. So clearly the court is much less willing to, muddy the pool by questioning whether really there isn't an issue with the right to property or fundamental rights, access to a lawyer, etc. Now, I think where the court is trying to play a role to maintain a form of balance, stability, really is in the interpretation of listing criteria. Here, the court still tries to preserve the margin of appreciation of the council while saying that listing criteria to target individuals are not an open-ended menu that you can just dispense with and use depending on who you want to target. So I think the court is trying to maneuver here. But again, the court is in a very difficult position, being still supposed to be a marginal actor in the field of foreign policy, having progressively gained more salience in that area of EU law. It's still a rather new actor in it. It's still pushing the boundaries of its jurisdiction. So I think for the court, it's very delicate to lecture the EU about its own sanctions practice.
And at the same time, it's being asked increasingly to provide very concrete guidance on how to implement the measures. So I think this is quite a challenge. Where do you see this going, moving ahead?
I think right now we have a certain momentum, if I may say so, in the case law because of the Russia sanctions and all the attention of implementation and all the questions that this raises in the cases. And so of course now the Russian cases might provide the court more opportunities to define aspects of sanctions. Now the question is, will in the coming year that trend confirm itself with other sanctions regimes or with other preliminary questions? I do hope that with the Russia sanctions, the national judges are getting used to asking questions to the court. We saw that before the Russia sanctions, this was not really the case, either because we had less domestic litigation or because simply the judges did not ask. I do hope that the preliminary question will become a reflex in applying sanctions law. This is the most efficient way for the EU to really see concretely where the problems are at national implementation. This is also a test case for the clarity of the court case law. So I do hope this will continue. Perhaps one day the Council will issue more binding guidelines beyond the mere best practices and sanctions guidelines.
From what I remember, the jurisdictions that are allowed to submit a question or refer questions to the court is fairly limited, right? It has to be courts or tribunals in the member states. I suppose that would exclude national competent authorities that are looking at potentially issues of interpretation. However, have you seen national competent authorities intervene in references for preliminary ruling that raise major interpretative guidance, particularly potentially in cases where there might be differences in opinion between NCAs?
I am not sure that I have seen that. It's very possible, but I would need to double check the cases again. What I do think is that it might be more likely to see member states at government level intervening in the cases, which also says a lot about the political implication of the cases. But I do think there is something out there for member states to learn from the cases, but also make their views known and provide additional information, additional feedback on how difficult it is to implement the sanctions. So indeed, this is an interesting development.
Perhaps before we conclude, Celia, could you share with us a little bit some information on the Minos network? What is it? When was it created? What's the network been up to? And where can we find more information about it?
Of course. The Minos network, that stands for the Multidisciplinary International Network on Sanctions. This is a rather new project that was launched in 2024. It is a research and academic-led project operated by Ghent University, which aims to foster education, research, and advice in the field of sanctions. So we have partner universities, think tanks, but we are also in touch with practitioners from the public and private sector, such as yourself. And the idea is to organize events, facilitate trainings, accommodate research days also by researchers in the field of sanctions. We have book lunches and we will be organizing courses soon.
Well, and that's quite an active forum, and it shows again how important the cooperation between academia, the private sector, and the public sector is in this field. Celia, thanks again for joining me on this episode. It was a real pleasure taking a deep dive in the world of the reference for preliminary rulings in the context of EU sanctions. Thanks for sharing your thoughts and your research, and look forward to reading more of your articles.
Thank you for welcoming me. It was a pleasure to discuss.
This concludes this month's episode. If you've enjoyed the show, please follow the podcast and share it with your colleagues or peers interested in EU sanctions law and policy. Don't forget to subscribe to the LinkedIn newsletter if you haven't already for additional materials. Thank you again for listening, and tune in soon for the next episode.